fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Welcome to the show. I am your host, Daniel. Today is Judge Brian Oakley. I want to thank everybody who was watching and rewatching my content. And by all means, please share this stuff out on the internet. Let people know that this channel is here and what we're doing on this channel. And let's get up to past 500 subscribers before the end of this year. I know we can do it, or we will come very, very close to it. And if you are not a subscriber to this channel and you like this content, both the court and the live scanner feed, please do me a favor and subscribe. Let's make this channel great again. So let's get started with Judge Oakley. Brian Oakley. Yep. Make it bigger. And I'm still here, so don't worry about it.
This case if we don't have something. So give us time so Detective Rice can make some phone calls.
Can I get 1 minute to step outside real quick?
I don't need you on this because he's the one that's going to try to figure out what happened or what can happen. Right? Okay. Yeah, take your time. Take your time. Yep. You got something ready? With Mr. Muhammad?
Yes, sir.
Okay, I guess we'll have to wait for him then. What's the file name?
I have another file. It's a transportation missing here. I already spoke to Mr. Muhammad about it. I think we got it resolved. But since I just rolled in, it's for Sandman Trucking. It was scheduled earlier, Your Honor, but we talked about it yesterday, and he said it's coming right away from my prelim.
Do we got a file on that one, Heather?
We should, because it's.
Oh, you know what?
It's probably in your notes.
Yeah, it's in the no-shows.
So I gotta wait to get the red out, saying, so it's ready to go for the prelim whenever.
Okay. And Mohammed's doing some paperwork on Sandman?
Yes, sir.
Frank, how do you say your last name?
No.
No? What's your client's name, Mr. Mullins?
Back.
Back is with a B.
I've been known to sloppily speak.
I've been known to sloppily hear, so. All right, back, it's got it. All right. So I've got both your files when we're ready.
Thank you, Rick.
So having fun?
Are you observing?
She wants to be a judge. So she's been bouncing around between the prosecutor's offices, the MIDC, just kind of being heavily exposed today. Yeah, it's pretty fun. Gentle Joe. Mr. Mohammed, are you ready on either Bacchus or Sandman?
Yeah, I'm ready on Docket.
Okay. Oh, we lost Mr. Mullins now.
Yeah.
I have the FIP charge in my office. Can I grab it? Certified records.
We're making you just do all kinds of stuff.
No, it's okay.
You're getting your steps in. I don't know what an FIP is. So. Back row, what's your name? Stokes? Who's your attorney?
It was Crystal Medina.
Have you talked to an attorney today?
Yeah, they said I'm waiting on paper. Yeah.
Oh, but wait, you're waiting for an adjournment, correct? No. Yeah.
Yeah, we haven't talked to anybody. So I don't know what the next one is.
I think she was waiting for him to, the prosecutor to write it notice, but she left.
Well, let's see if Mohammed knows what the agreed date was. It's not moving. It's not flowing. It's not flowing. You got sidetracked again. So. Huh?
Medina left.
Right.
Yeah.
So.
Mohammed's getting it from everywhere.
He's being pulled all over the place.
Back, this is here.
Mr. Mohammed is getting pulled in at least 3 different directions, and I'm ready to pull him in the 4th right now.
So Sergeant Otter is trying to find out. Handles that.
Okay.
Judge, we're gonna have a resolution on.
All right. I know you're getting pulled all over. On Stokes, Miss Medina's client, I think there was an agreed adjournment.
Yeah.
Do we know what it was?
Yeah, we got it.
Okay. All right, Mr. Stokes, we're gonna get you out of here, brother. Ryan, bring it up. Thank you. Got it. Okay. We're gonna get your written notice, Mr. Stokes. Heather, we're doing this for Valentine's Day. I don't care. 10:30? 10:30 on February 14th work for you, sir? Wear red, it's Valentine's Day. That's all right. I'll at least have a red tie on. If I don't forget. Not a problem. Grace, you getting your questions answered?
Yes, that answered everything. Excellent.
No problem. We'll have you back here any day you can come.
Thank you so much. I really.
As you can see, Wednesdays tend to be a little bit
The best day.
exciting.
Yeah, for sure.
And just so you know, if you want to, especially on Wednesdays, because Wednesdays we can guarantee there's going to be something to watch. Okay. You don't have to set it up ahead of time. Just roll in, tell the guys at security, I'm just here to watch. Yeah. No problem.
Amazing, like truly.
Oh, I'm still willing to sit down with you as soon as we get a break.
Well, I think she's gonna be an attorney or a prosecutor. She doesn't, you know, she's got all that side and she obviously seems to be excited on that side.
Oh, one thing you'll find about people in this profession is most of us really like to talk about it.
There's lots of officers here too.
You don't want to be a cop. And I don't think you'll find a single one here that would try to talk you into it. Yeah. Oh, whenever you got to go. Yeah. You got any questions for me? I was in private practice. I hung up a shingle after law school. So I was in private practice and I had gotten tired of the business end of it. People that came in crying, you fix the problem, then you send them a bill for $300 and they complain. You know, just that kind of stuff. And I was trying to figure out how I was going to change my practice so I wasn't having so much of that, or find something else I could do with my law degree. And at about the same time I was going through that kind of soul searching process, Judge Green was elected. And when she was elected, she was 31, I think. Do you remember? The joke was she wasn't as old as the courtroom, which was 34. And it really changed the way I thought about judges, because back then pretty much judges were attorneys that had been in private practice for a long time. Most of them old white men, in our area at least. And as a semi-retirement gig, they got on the bench somewhere because there was a benefit package, whereas most private law firms back in the day, you didn't get a retirement package, you probably didn't get any kind of health care, right? Especially if you were a sole practitioner, unless you paid for it yourself. So it's kind of like a semi-retirement gig. Well, when she did that, I got to thinking, well, wait, maybe I don't have to wait until I'm 60 years old to think about that. So, and I was always involved in community stuff. So I thought, all right, I got a law degree, that I worked real hard to get myself through 7 years of school. I like to be involved in my community. Hey, in 1998, lost by 1.131% of the overall vote. And it was really funny. And we always had a great relationship, Judge Linus and I. And then when I ended up working with him after I got elected 2 years later, we always had a good relationship. But the day after the election, and we got along fine during the election, we'd meet somewhere and I'd give his wife a kiss, he'd give my wife a kiss, we'd shake hands. It was all very cordial, the way politics can be and should be. So the day after the election, Susie and I are headed up north. We're getting away because it's been grueling. So I called his house to congratulate him, and his wife said he was still sleeping. I said, don't wake him. I said, just tell him I called to congratulate him. She says, Brian, you won. I said, no, Ann, we didn't win. I said, what time do you guys go to bed? She said, oh, it was about midnight. I said, well, Huron's last votes didn't come in until after 1. I said, I lost. She said, are you sure? I said, absolutely. That's why I called to congratulate you. She said, I'm going to wake him up to tell him that. That's how close it was. Yeah. So anyhow, long answer to a short question. I love the practice of law. I didn't like the business end of it. And I was trying to figure out what to do with it. Yeah.
Did you get elected or appointed, Judge?
Elected.
Okay.
Yeah. And looking back on it now, there's no doubt in my mind that it was completely meant to be. I think I was called to the bench. I think there's a lot of things in my life that God just made fall into place the right way. So yeah, until COVID, it was a great gig. Yeah. Yeah. COVID changed too many things to suit me. Are we ready on Tigman?
Yes, we have a resolution, Your Honor.
Tell me all about it.
Yes, so the representations from the OIC and the prosecutor's office, because the complainant is here, is that if Your Honor was to dismiss this case, they would refile. I have discussed that with my client. We've come to a resolution to a plea to the high court misdemeanor of joyriding. I'm going to give you the MCL code, but my internet.
Yeah, give me the NCL when you find it.
Sorry,
That's all right.
you leave your computer too long and it.
Hey, Joe.
So he's going to plead to motor vehicle use without authority, but without intent to steal, MCL 750.414. That's a 2-year misdemeanor. We've come to an agreement, Your Honor, to a 6-month term of probation with drug treatment and restitution in the amount of $350. I would ask that this court consider waiving not discretionary costs and fines in this matter, because restitution is going to be quite the challenge for Mr. Tigman. He's currently homeless, and as is reflected by the fact that he needs drug treatment, struggling with addiction, which is the underlying cause for, and the prosecutor can agree, the sealing of this or the temporary taking of this vehicle. He does want to make the complainant in this case whole for the cash that he took out of the car.
Okay.
So that would be his priority.
Sure.
And with probation, hopefully he's expressed interest in treatment. I'm hoping probation can refer him to treatment services
Yeah.
to be completed.
Yeah. All right, so Mr. Teigman, we're using a Caseville Road address in Westland. Is that a good mailing address?
Yes.
Okay, all right. Physically, where are you laying your head every night? You bouncing from couch to couch? What are you
I
doing?
was, yeah, what the Westland address and another friend's house. So
Okay.
I'm, I'm not in the streets.
Okay.
All
All right.
He also, I mean, at the time of this was at an extended stay motel, so. he's
Yeah.
bouncing around.
Yeah, so there's where all his money was going. So I don't like to order treatment
Okay,
without any kind of evaluation. So what I'm gonna order is a substance abuse evaluation, and then based on that evaluation, whatever level they think you need, that's what I'm gonna order. Understood?
Yeah.
Okay. All right, so you understand the possible penalty for this new charge?
Yes.
And you understand your rights and options?
Yes, sir.
All right, understanding all of that, are you pleading guilty freely and voluntarily to the added charge?
Yes, sir. Yes.
All right, would you like to voir dire to give me the facts?
Yes, and obviously the felony is going to be dismissed. as part
Correct,
of- yes.
correct.
Mr. Teigman, on or about November 23rd, 2023, on Marion in the city of Romulus, County of Wayne, were you present at a gas station? And at that gas station, did you take a vehicle and drive it away from the scene that you did not have permission to use?
Yes.
All right, no further, and was that vehicle a Lincoln MKZ?
Yes, it was.
Okay, no further questions.
Are you satisfied?
Yes.
Mr. Mohammed, you satisfied? So am I. One other thing, I'm not gonna put you on for 6 months. I'm gonna put you on for 12 months with the understanding that if everything goes the way it's supposed to, you can always ask me to terminate it at 6 months. But depending on what the treatment plan is, they might want you in for a long time. I don't know.
That's fine.
Okay?
Yeah.
All right. So I think what the agreement was, substance abuse evaluation, restitution of $300, right?
350.
350? All right. Okay.
Yep.
All right. All right. So here's what I'm going to do. I'm going to sentence you to 0 fines and costs.
Thank you.
Merry Christmas. $350 restitution. You can set up a payment plan through the probation department. Substance abuse evaluation, which you're going to get information from the probation department. And when you meet with the probation office, tell them you need to speak to Mr. Taylor, who's in that department, because Mr. Taylor's got real good contacts right next door with Wayne Metro, and they've got some programs for homeless folks. I don't know if they can do anything quick for you, maybe not, probably not, but let's get you tapped into whatever resources are available for you. All right? You got all that?
Got it.
Questions?
No.
Counsel?
No, Your Honor, thank you.
All right. Good luck, Mr. Tigman.
You said 750-414.
Nope, it's 750.414.
Right, that comes up still as unlawful use felony.
So I'm reading 750.414, a person who takes and uses without authority any other motor vehicle without intent to steal, or who is a party to such unauthorized use taking, is guilty of a misdemeanor punishable by imprisonment of not more than 2 years. So it's a high court misdemeanor, which for sentencing guidelines purposes is a felony, but is
So
it?
it'll show up as a felony for the 414.
I suppose, but it is a misdemeanor, it's a 2-year misdemeanor.
In our system, it just comes up as a felony.
I think we could take it. So we'll work it out somehow. way,
I
shape,
mean, I can
or form.
show you right here on the MCL code that it's a high court misdemeanor.
She just,
Yeah.
the system's telling her one thing,
Yeah,
so.
yeah, okay,
Okay.
all right, understood,
Thank you. Good luck.
thank you.
Are we ready on Bacchus when they're ready on
He
Bacchus?
reports probation downstairs,
Yes.
okay.
And Judge, in regards to restitution, how do I, explain to the victim how to get that?
Is the victim here today?
Yes.
Beautiful. Ask her to go down to probation counter. Let them know she's here on the Tigman matter, and they'll get all her contact information. So when Mr. Tigman is able to start making payments, we can get the money to her.
Okay.
All right? Actually, you know what? You mind doing that? I want to keep him up here working. All right? Thank you. Be safe.
We'll be back in there for another one.
All right. Bacchus! If they're ready. I don't know if he's trying to talk his guy into something or. Are we ready, Mr. Mullins? We ready?
I'm ready, I just don't know if the victim is here, I didn't see it. Oh, he is here, okay.
Ryan, did you have some paperwork on Sandman Services?
No one appeared for that, I don't believe. Yeah.
I thought that was Mr.
Oh,
Mullins.
the registration one. Oh, we didn't have a ticket for that, we didn't have a copy of the ticket.
No, what are we doing on it?
So as long as it reflects that it was a registration issue, I'm gonna dismiss it based off of his.
Can you
him
hand him
producing-
this file?
Just a straight out dismissal?
Yes,
Okay, what does he need it for?
Oh, I thought he said that that's what he needed.
No.
yes, so for Sandman, it's gonna be dismissed due to, it's just a registration, right?
Yeah, it's registration or plate violation, commercial vehicle. And I've got the actual ticket if you need to compare it.
Yeah.
Are we ready on Bacchus though?
I'm ready with it, yes.
Okay. Yeah.
There's no counter people anymore.
Oh, that's right. Even if she just gets his contact info, that's all right. We shouldn't have to sitting down and talking to them.
Right, but somebody had talked, I didn't want to.
Right.
Judge, is it okay if we discuss this after the exam?
Yeah,
Thank you.
Good.
yeah, I'm just trying to do quick stuff.
Yeah,
Yeah.
thank you.
Yeah, well, sometimes it's not quick.
Absolutely.
I don't have the answers.
Absolutely.
We're
So we're ready on
on
Bacchus? All right, appearances, gentlemen?
Good morning, Your Honor. Mohammed on behalf of the people, P86771.
Good morning, Your Honor. Robert Mullen on behalf of the defendant, Mr. Bill Backus. He's moving up to the table.
Bacchus or Bacchus?
Backus, Your Honor.
Thanks.
Okay, go ahead. Have a
Good
seat.
morning, Your Honor. Miles Drew, also on behalf of Mr. Dylan Backus, P number 84554.
Good to see you.
Mr. Backus, could you please state your name for the judge?
Dylan Backus, Dylan Kevin Backus.
Thank you. Nice tie.
No, thank you.
Your Honor,
Yeah,
is
he's
it
been
possible
here.
an extra chair?
Yeah, we'll steal one of theirs because Ryan's already on the pew. We'll put the OIC on the bench when he gets back.
Let me just grab mine. I'm ready to go wherever.
We're ready. You ready to call a witness, Mr. Mullen?
Yes, Judge. This is a quick preliminary matter, just for the record.
Yeah.
We request a mutual order of sequestration.
Okay, and given the fact that we've got nobody in the buildings or courtroom except Gracie, we know she's not a witness, we're ready to go.
And we've kept everyone that's potentially a witness, either preliminary exam or if a trial occurs out of court. But
Thank
there
you.
is some family support that might be able to do that part of the case.
I'm okay with family support as long as they're not prospective witnesses.
So,
Who's the first witness?
Judge, it was just brought to my attention that the victim indicated to my colleague that he's afraid of some of the family members that are outside because they advise him like not to move forward with the case or something happens.
I'll let you guys go out there and talk to your victim and make sure we won't let those people in the courtroom if it's intimidating to the victim.
So thank you.
Yep. I do like that kid. I'll tell you what, being likable will cover up a lot of mistakes. I don't think so. Mr. Drew, you didn't work at the prosecutor's office, did you?
No, I did intern there.
Yeah.
briefly.
Intern,
So Did
okay.
you come here at all doing it?
No, I was mostly in 36 district.
But you've
court.
been here before as an attorney.
Yes, yeah.
Yeah.
I represented a gentleman on a gun case here maybe
Okay.
about a year ago.
Okay,
Yeah, and I held an exam.
I don't think that was the same tie though.
No. I usually have ties that are in this vein though. Figured it's the
I
one thing in a
like-
suit you can kind
I
of,
like bright ties.
thank you, yeah.
Yeah, life is too short for boring ties.
Could not agree more, Judge.
No offense, Mr. Mullins.
That's all right, Judge. As you get older, you get, hey, Judge, remember, nice to have that hair, you know, sometimes you got to throw it around. You know?
Vending machines and stuff downstairs, or I have room cards.
So Judge,
Yeah.
I think it's in the best, I think the best case is to have this empty, the room empty with no family members or friends. Based off my discussion with the victim.
All right, so my understanding is the victim has felt intimidated by certain family members of Mr. Backus.
He doesn't want anyone.
Well,
We'd like,
If your victim's had no contact with these folks, it's an open courtroom, I'm gonna leave them here. It's not, your victim's not a kid, right?
we're not, yeah, that's what I was gonna say.
No,
I mean,
I'm not gonna close the courtroom if it's not a child victim. If your victims had contact with these people directly and felt intimidated, then that's one thing.
have you had contact with them over 3 years? Not over 3 years, not anything to do with this particular case at all.
Then let's bring your victim in and put him on the stand. Blame me.
Your Honor, the people called Mr. Joseph Backus.
Sure, Martin, you got something else on?
Yes, you have, Crenshaw, 17 April, Crenshaw.
I don't think so. That would be Joe's fault if I did. I did. Oh, okay.
He was gonna get a hold of them next
All right,
week.
then it's legitimately on Joe's list. Okay. Oh, that's right. That's what you told me yesterday. You're gonna have us late people or early people show up late.
Judge, it's been brought to my attention.
You know what his options are.
Can I please just have 30 seconds?
Sure.
That's what you don't lose. Okay, thank you. She'll be courtroom. I'm sure everyone will hear me. I'm pretty loud. She asked me to. Where is it, officer? Oh, so I pushed it so that everything I say isn't being, do I hold? Yeah. Okay. Good. All right. Thank you, because I'm always talking and saying stupid things, and we do not want to have that recorded. One time I was in federal court doing a trial. You know, I'm like,
Folks, give me your names loud so you're on the record.
Danielle Watson.
Brendan Watson.
Thank you.
It's not about beating it. Yeah.
Sure, no problem. Do you want to do that? I appreciate it.
I'll be
Yeah, go ahead. You heard this officer. Nope, have we?
Yeah.
I don't recognize the name, and that's one you should recognize. Yeah, I figured that.
Judge, I'm sorry. The back and forth. The
Sorry.
witness is coming.
That's fine. Mr. Backus, all the way up here. Watch my step, my incline ramp here. Don't trip up. Raise your right hand for me, sir. Do you swear or affirm the truth, whole truth, and nothing but truth today? Have a seat right here. Settle in that chair and then state your name loudly for the record.
Joseph Backus.
Thank
Your
you.
Honor, I have permission to move so I can see the witness.
Sure, move around.
Thank you. Go ahead, you go back to where you were. I'll just.
Yeah, as long as Heather picks up everybody that's talking, I don't care where everybody's at. Go ahead, Mr. Mahoney.
Good afternoon, Mr. Backus. Can you please restate your name for the record?
Joseph Backus.
Mr. Backus, I'm going to take you back to the day of November 4th, 2023. Were you at the location of 20259 Middle Belt Road in the city of Romulus, County of Wayne?
I was.
And what's at that location?
My father's house, the house I grew up in.
And what took you to that location?
I have a 2-year-old daughter that's never met her grandfather, and I myself never met my grandfathers in my life, and I tried to make a better life for her and give her grandfather a chance to be a part of her life and meet her, because she's a beautiful young girl. She deserves to have all her family in her life. I wanted life to be different for her than it was for me. Upon going there and trying to see my father.
Okay, let's
Yeah.
stick to questions and answers.
Okay, so that's what brought me to the house that day, is
I
to
understand.
give my father a chance to be a part of his granddaughter's life.
Okay, thank you. And did something occur?
Sorry.
Did something occur at that location that brings you into court today?
Yep, I knocked on the door. I was not greeted by my father. My brother Dylan answered the door.
Your brother Dylan, do you see that individual in the courtroom?
Yeah, he's sitting over there.
Can you please point to that individual and point out an article of clothing that individual is wearing?
That's the gentleman in the gray shirt.
Your Honor.
Noted.
Thank you. And what happened, if anything, upon interacting with your brother?
He opened the door. He asked me what I was doing here. I said, I'm trying to see dad. I'd like to let him see my daughter. Pointed at my car, so he was aware my daughter was in the car. Upon my response, he reached into his pocket and pulled out a pistol and proceeded to put it in my face and told me I better get to stepping while I have a chance. I proceeded to walk backwards, not breaking eye contact, to be aware of my surroundings until I got in my vehicle, left, got down the street to get my daughter in a safe location and called Huron Township Police.
Okay, and you described a weapon was aimed at you, correct?
Yes, a pistol, a
And can you
handgun.
describe this weapon?
Yes, it was the lower part of it was a lighter gray. The upper part was a darker gray or a black. Handgun looked maybe a 9mm.
Where was it pointed?
That was about 6 inches away from my face, with the barrel facing my face.
And where was your daughter when this weapon was pointed?
Approximately 15 feet behind me in my car, in her car seat.
And when this weapon was pointed at your face, how did it make you feel?
Made me feel like I needed to get somewhere safe for my daughter. You know, needed to leave that location and get out of there because I have a 2-year-old daughter with me and now there's a gun involved in this incident.
Was there any other feelings that you felt when this weapon was pointed at you?
And not really, a panic came over me. I just knew I needed to leave and get somewhere safe.
A what came over you?
A panic, like you know, I
panic?
feel something bad could happen and my daughter's life could be at threat if something happens. So I need
Did
to
you
leave
fear
this
for your
location.
life?
Yes. I mean, there was a gun in my face.
I understand. Nothing further for this witness.
Mr. Mullins, your witness?
Absolutely.
Now, sir, you wrote a statement in this case where you contacted the police. Is that correct?
Yep.
And you put everything, you were truthful when you made that statement.
Yep.
And is that a yes?
Yes.
And in fact, the only reason you made a statement was to tell the truth as to what happened.
Yes.
And you were not under any restraints in time. No one told you you had only had so much time to fill out that statement.
No, the police met me after I called them and they gave me the statement. So here, can you just fill
They
this
said
out
you have
and
all
sign it?
and they said, oh, you didn't have any time constraints in filling out that statement, right?
Objection, ask and
I
answer.
just want to make sure I got that out there.
Yeah, it wasn't clear. Nobody said fill this out in the next 3 seconds and hand it back.
No, they just
They
said,
gave you
newspaper
time.
and said, here's this, you had all, I actually walked away and sat at my car for a moment, you know, had time to
Got it.
replay the incident in my head. I had all the time in the world to do it. I mean,
Okay.
we did
Okay,
this.
okay, move on, Mr. Mullins.
The individual that you pointed out as the defendant in this case, that's your little brother.
Yes.
He's 5 years younger than you.
Objection, relevance.
I'm just establishing the relationship.
I think it's fair.
You guys have not had the best relationship over the years. Isn't that true?
That's how you like to put it.
Well, I asked you a question. You can say no. That's a yes or no question.
I haven't talked to him in 2 years, so it's kind of
And
hard to say we have a relationship at all.
Okay, and you say you haven't talked to him in 2 years. You haven't talked to anyone that lived in that residence for over 2 years.
objection, relevance.
What's relevant?
The relevance is the relationship that was going on, whether or not he should have been at that. There's all kinds of questions that's related to the relationship, and it goes to my client's state of mind in dealing with his brother, because there's issues of whether or not it would be reasonable for his behavior under case law as an affirmative defense that even in a preliminary exam you can consider, as well as credibility of the witness. All these questions are relative because these are not normal relationships, Your Honor, of strangers. These are relationships that have been born over years and they can affect people.
I'll allow it.
2 years ago, you were removed from that house that you went to on that day. Police had to is your testimony the police didn't show up and escort you off that property
They
that
did
day?
not escort me off that property. They were there allowing me to get my belongings and leave. They
Right.
it was never escorted.
You were no longer welcome on that property at that time. Isn't that true?
I don't recall any type of court paperwork or anything stating
I'm
I'm
not-
not allowed to
I'm
be
gonna
there.
object to the relevance.
I think it's relevant. I think he's right. It goes to the state of mind of the defendant.
You were not welcome on that property by any of the residents that lived on that property.
Objection, speculation. He's speculating to the state of mind. of
It's a statement too, and I don't like that. So
All right.
start asking questions.
Sir, your father did not want you on his property
objection.
when you
What's the
left
objection?
2
Hold
years.
on. What's the objection?
Speculation. Speculating. to
I
what?
think he's trying to ask a question. He's just having trouble asking it in the form of a question.
Understand.
Isn't it true? Your father did not want you on that residence. He wanted you off that property 2 years ago when you left.
I'm gonna object, Judge. Speculation.
I don't think it is. Did your father want you on the property? Well, a better question would be, did your father make it known to you that you were not wanted there?
No,
Have you talked to your father in the over 2 years from when you left the property to when you arrived on the day in question
no,
on
that's why I was
wait,
there to give him a chance to be a part of his daughter's life. It could have been handled better than
All
a
right,
gun in
sir.
my face.
Sir,
In-
this is the third time I've asked you to answer the questions.
I'm
Now,
answering them.
you can argue with me, it's not going to end well for you. If there's a question that's been asked of you and you can answer it with a yes or no, do so. If the prosecutor thinks there's more information that has to come out, he can ask you more questions.
Okay.
But you're not up there to narrate and get your story out. You're there to answer questions. Understood? Try again, Ms. Welch.
Isn't it true, sir? You did not speak to your father for over 2 years after you left after you left the family home that you lived in.
Yes,
And in fact, you hadn't spoken to your brother in over 2 years during that time period.
yes,
And you hadn't spoken to your sister in over 2 years during that time.
yes.
And those are 3 people that lived at that residence on November 4th when you showed up. To your knowledge, if you know.
Objection.
No, my sister didn't live there.
You don't
Okay.
have to answer.
That's fair enough. And you had reached out to your father during that 2-year period through text messages.
Is that true?
Is it true?
True,
And you never got a response from your father. Is that true?
true.
And in fact, you had asked him about coming over 2 days before you showed up. You had sent him multiple text messages about coming over to visit
No.
and did not receive a message.
Not true.
You have never, in those 2 years, isn't it true, in those 2 years, you have never been invited over to that house?
True.
And in fact, when you've had a relationship with your brother for most of his life, right? As his older brother, isn't that true?
True.
And there's been times where that relationship has been physical between you two. Isn't that true?
True. What brothers don't get in fights?
Sure. And you're the older brother, isn't that correct?
True.
And 5 years old. Is that true?
Objection, relevance.
Relevance is to show the age.
Relationship. I'll allow it.
I'm not 5 years older than him.
Are you 4 years older than him?
True.
All right. And isn't it true that when he was 13 years old, you duct taped him to a chair and pushed him down the stairs?
Objection.
Not true.
That's not true?
No,
Are you saying you've never been, isn't it true that you've been physical and beat up your brother in the past?
I think you gotta narrow that down. I mean, if, you know,
Well, Judge,
it was 10 and 6 and they had a fist fight, I don't really care.
in the last 10 years, you've beaten your brother up. Isn't that true?
not true.
Not true? When's the last time you beat your brother up?
Couldn't tell you. The last fight we got into, I actually got 11 staples in my head. So
When was that?
couldn't tell you.
Now, during that 2 years that you weren't living there, would it be fair to say that you had a hostile relationship with both your brother and your father?
There was no
I'm
relationship.
gonna
Not
object,
true.
Judge. The attorney mentioned that he had no contact with him for the last 2 years. So now he's saying it was a hostile relationship for the last 2 years. It's one or the other.
It's not
Either there
one or the
was a
other.
relationship or there wasn't.
If I get-
Well, in an earlier question, Mr. Backus said he considered it to be no relationship. So I don't know how it could be a hostile relationship. It was a non-relationship according to this
Well,
witness.
just give me just a little latitude here, Judge, and I'll fill that in. Isn't it true that you had sent a text message within the last?
Objection, hearsay.
Wait,
Let him get it out. Don't answer it.
isn't it true that you sent a text message to your sister indicating, referencing Dylan as the scumbag brother?
Objection, hearsay.
It's not hearsay, it's his statement. If I was,
He's
if
not
I,
the defendant, respectfully.
no, it's the witness's statement I'm asking him of. It's not hearsay. He can testify to whether or not he made that statement.
He's not an out of court declarant. He's right here. I'll allow
Didn't you refer to your brother as the scumbag brother in a text message you sent to your sister in July of 2001?
What year?
2001, July.
I was 6 years old. I didn't have a phone.
In July,
2001?
I'm sorry,
Yeah, I was 6 years old,
2021.
I didn't have a phone.
You are correct, sir. My math is not as good as it used to be. In July of 2021, didn't you reference your brother as the scumbag brother?
Don't worry.
And I'm gonna object for the record, Judge.
Well, would that be something you would say about him?
No,
So your testimony is that that's untrue? Is that your testimony?
Yeah.
And is it also true that in that same text message that you sent, that you called your father a loser
And
father?
I'm gonna object again, Judge, for the record, that's hearsay.
Again, Your Honor, it's a statement.
I don't think it is. I don't
Isn't
think
it
it's
true?
hearsay.
No. Your testimony again today is that you never referenced your father as a loser.
And I'm gonna object for the record, it's relevant,
Now,
not relevant.
when you walked up to that house with your daughter,
Didn't have my daughter, she was in the car.
she's in the car. And when you came up with your daughter in the car, you didn't know if your dad was there or not. Isn't that true?
Yeah, I can't see some walls, so no, I didn't know who was in there.
So you had texted your dad and told him you were coming, didn't
No.
you? So it's your testimony today that you never reached out to your father in a text message that you wanted him to meet your daughter prior to you showing up.
I said, meet my daughter. I never said come by the house. I
Okay?
said I was gonna come by, I said, meet your granddaughter. Yes, that was stated in the text. Would you
And-
like to meet your granddaughter?
And you never got a response. Isn't that true?
True.
And in fact, any text that you sent to any,
Objection.
That's asked and answered. All right, let's move on. I've given you a lot of leeway. Let's get to current events.
so on the date of the event, you said that your brother pulled out a gun. Did your brother isn't it true your brother told you to leave before he even showed you a gun?
No,
He told you to leave 5 times that
did
day.
not.
And when he had his gun, he never pointed at you. Isn't that true?
It's not true.
In your statement, you had indicated he pulled it out of his pocket with the barrel almost inside the pocket. Do you remember saying that in your statement?
The whole gun
And I'm
was in
gonna
his pocket.
object, Judge, to hearsay. for the
It's
record.
his statement.
He's quizzing you about his own statement he made to the police. It's allowed.
Don't you recall saying that in your written statement?
Yeah, that's,
Okay. And in fact, is it also true that when you interviewed with the police, you identified your brother's gun, right? And is that a yes?
yes,
And is it also true that you identified your brother's gun as a black gun with a silver handle? Isn't that what you told the police? And they interviewed you on 11/4 after this incident.
the hand, where you hold the gun was gray. The slide, the top part of the gun, the slide was a darker gray or a black, is what my
Well-
statement was.
Is that what you're claiming you told the police? Is that what your statement is in court that you told the police?
I wrote it down, you can read it.
No, I'm asking you what you told the police when they asked you to describe the gun. I said-
I said what was written on the paper.
Well, let me slow down and ask the question, and you just tell me if this is what you told the police. I'm not asking you what you wrote down. Before you wrote down your statement, you interviewed with the police at the gas station. Isn't that true?
Yes,
Then they gave you a piece of paper and you went and wrote down whatever it is that you were going to say. Isn't that true?
yeah,
And when you were standing there and being interviewed by the police, you were asked about the gun and you described the gun.
Yep.
Is that true?
yes,
And in your description to the police, when they were speaking to you, you told them it was a black gun with either a silver or black slide. Isn't that true?
no, I said dark gray or black. Said it
Okay.
3 times.
And you actually even described that gun as a Ruger 9mm, didn't you?
I said it could have been a Ruger. The barrel was pointing down my eyes, looked to be about a 9mm.
So you didn't see it when he pulled it out of his pocket?
Yeah, I seen it when he pulled it out of his Carhartt pocket and proceeded to bring it up to my face.
Right? You have the ability to play his statement back on the body cam through there if we hook up our HDM.
I don't know if you do or not. I'm not a tech guy, so
We've got.
I know if it's done correctly, it'll do it.
We checked yesterday.
Well, when I'm done with questioning, then maybe I can go back and do some impeachment of the
Fine.
statement. Now, isn't it true that when you spoke to the police officer, you stated probably 5 times that your brother brandished a firearm in front of you? That was your statement to him when they were talking to you at the gas station.
Yeah, that'd be the legal term of pulling a gun on somebody's brandishing a firearm.
Okay. But you weren't necessarily saying he pointed it to you. You were saying he brandished it at you.
He brandished it and proceeded to put it in my face.
So was it all in one action, or did he have it out and kind of show you for a
He
while?
pulled his hand like this out of his pocket, gun was in it, pulled it out and put it in my face like that. That's
All in
exactly
one-
what happened, all in one motion.
Okay, all right. Now, is your testimony that your brother never told you to leave the restaurant, never told you to leave the residence?
On
After
November
the
4th.
firearm was
On-
pulled, he did.
11/4.
Not until after he pulled the firearm.
Okay.
And
And-
Judge, I'm gonna object, ask and answered.
Probably was. Move on.
As soon as you came to the door and spoke to your brother, you inquired if Dad was there, correct?
No, I didn't ask. He asked me what I was doing there. I said, I'm here to see Dad. That's when he pulled the firearm and said, well, you better get to stepping while you can.
Did you ever receive information as to whether or not your dad was there?
No, because he pulled the firearm, maybe I left. I had a 2-year-old kid in my car.
Your daughter wasn't outside of the car, right?
She was about 10 feet behind me in the car.
Good.
Bullets go through things.
How long is it with you? Your Honor, we're gonna ask play body cam of his statements to the police.
And Judge, I'd object, there's no foundation that's been laid.
Well, all right, fair enough. We
That's
can
fair
do it to the
question.
police officer. We'll just call him and he can identify it as his body cam and all of that.
Okay.
Just a second to make sure I'm either done or not done with this witness. Before you went there, you spoke to your uncle.
Objection, where's there, Judge?
Wait, before you showed up with your daughter at your dad's house, you had a conversation with your uncle. Correct?
True.
And your,
Objection.
and
He's already answered it.
when you had that conversation, did you feel encouraged to go to your dad's house based on that conversation?
Yes.
And why so?
My uncle never indicated that he thought it would be a bad idea.
Objection, relevance, not just relevance, hearsay, he's testifying to what his uncle said.
I asked him
No,
specific.
he's asking how he felt after the conversation. So that's not hearsay. What's the relevance?
Well, the relevance is what his state of mind would have been going there.
Okay, I think we've already established that he had no concrete reason to feel he would be welcome when he went there.
That's fair enough.
Which doesn't mean he can't still show up and try to
Sure.
mend things. So move on.
Sir, you wanted a relationship with your granddaughter, with your grandfather, your daughter with your grandfather, isn't that true?
Can you repeat that?
You wanted
It
your
didn't make
daughter,
sense, so I need to hear it.
it was important for you, for your daughter to have a relationship with her grandfather.
Yeah,
Isn't that
that's
true?
important in any kid's life.
Well, and you stated today it was important because you didn't have a relationship with your grandfather. Isn't that true?
True.
And you went over there and attempted to facilitate or put together a relationship with your dad and your daughter, correct?
No, I just let it be known, wanted to let it be known if you wanted to be a part of his granddaughter's life, definitely could be an option, something that could happen.
Well, didn't you text him that previous to you showing up, that if he wanted to meet his granddaughter and be a part of his life? Isn't that what you testified to previously?
Yeah. True.
So when you showed up there, you didn't need to show up there in order to get that message across, correct?
True, but he also did, I didn't get a response, so I didn't know which way,
Next
one way or the
question.
other.
Next question.
Is it, I asked you this question, I just want to make sure that I covered it. Your testimony is you were never told to get in the car and leave.
No,
And you were free to leave. You didn't feel like you were hostage there, were you?
no,
He never made a statement to you he was going to kill you, did he?
indirectly. He said you better get to step it while you have a chance. I mean, I guess it's up to your own interpretation on how to take that, depending on who you are.
Isn't it true, sir? You were upset with your brother for rejecting you when you showed up there with your daughter to meet
No.
his father.
Not true.
You weren't upset.
No,
It didn't affect you that you wanted to have a relationship with your daughter with the grandfather, and you were turned away at the door.
And I'm gonna object, Judge, to relevance.
Relevance to state of mind. And
State of mind's relevant. But he's answered the question.
wouldn't,
is it also true, sir?
no, but I didn't pull a gun on anybody.
Is it also true, sir, that you wanted your brother, when you spoke to the officer in this case, you specifically told them you were making that report because you wanted your brother to get a reality check, right? Isn't that what you told them?
True, we don't live in the wild, wild west. You can't pull guns on people like that anymore.
I don't have any further questions.
Mr. Muhammad, any redirect?
Mr. Backus, when you approached this location and you were greeted by your brother aiming a firearm to your face, did you have on you any weapons at that moment?
No. Also, there was a
No, there is no also. Last time I'm going to tell you, you ask, the question is asked, you answer it, and you stop. Next time you do that, I'll just throw you out of my courtroom and hold you in contempt, putting you in jail. Clear?
clear.
Mr. Backus, please just answer my questions. Now, did you knock at this door or did you enter the room?
I knocked on the door.
Okay. And did you ever enter this location?
Never.
And you mentioned earlier that, the testimony came out that you texted your father wanting to go over. You never got a response.
No, I never said I was gonna go over their house or anything. I just said, hey, you have a granddaughter. She would probably enjoy having her grandfather and her wife.
And so my question is, did he ever respond until you know?
No.
Okay. Nothing further.
Any recross?
I can't look at, I'd be expanding the record, Judge. I know better.
Okay,
And you've been generous with me, so.
thank you. Mr. Backus, you're free to leave. Watch your steps, sir.
I could like leave or?
Yeah.
Okay. I just want to make sure.
Any reason for me to stick around?
No.
Okay, yes, you can leave.
Have a good day.
You as well. Any other witnesses from the people?
Nothing from the people, Judge.
Defense witnesses?
We're calling a witness right now. We're seeing if he's going to come and testify. Uncle Kevin.
Sir, all the way up front, please. Watch your step on the incline ramp, all the way up here. Watch your step on this ramp. Raise your right hand for me, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? I do. Have a seat right there in that chair. Settle in that chair and state your full name.
Kevin Lee Backus.
Thank you, sir. Mr. Mullen.
Mr. Backus, do you know Dylan Backus?
Yes,
How do you know him?
he's my nephew.
And do you know Joseph Backus?
Yes,
How do you know him?
he's my nephew.
So would it be fair to say you've known them all of your life?
Yes,
All their life, rather, I'm sorry.
yes,
Did you have contact with Joseph Backus on the day that he came over? Let me give you the date, November 4th, 2023, which would be the day that he had an incident. First off, are you aware of an incident between Joseph Bacchus and Dylan?
I'm
Bacchus?
objecting, Judge, to leading.
I'm asking if he's aware.
I think it's fair. I think it's fair.
Yes,
And how are you aware of that?
because I ran into Joey prior to him going out there.
Okay, and when, prior to him going out there, you had a conversation with him,
Yes, I did.
and during that conversation, did you encourage him to go out there?
Objection, leading.
That's a yes or no. I allow.
I'm sorry, can you repeat the
I
question?
said, during that conversation, did you encourage him to go over to his father's house?
No,
Was there anything about his manner that you noticed when you spoke to him that day?
yeah, he came up to me, give me a hug. I could smell liquor on him. I would say my guess is whiskey, smelled like whiskey.
Objection, speculation.
It was.
But
And I just didn't want no confrontation. I gave him a hug back.
And Judge,
What's
I'm also gonna object to relevance. I don't know how, whether he was or he wasn't intoxicated, hypothetically, how is that relevant to the case we have before us?
It's a credibility issue. I'm more concerned with the timing. When was this meeting?
what time did you meet with him?
It was approximately, well, I don't remember the time of
Was it
day
on November
exactly.
4th?
It was on November 4th.
That's all I needed to know.
And, okay,
That's enough. I just wanted to make sure it wasn't 3 weeks before.
gotcha.
Was it before he went to his father's house?
Yes,
Okay, and
Objection, speculation. How's he gonna know that?
He's already answered it. Gotta be quicker.
have you ever seen your nephew, Joey, be physically aggressive prior to November 4th? And if you have, could you give us a time frame?
what timer?
No, a time frame.
Well, over the over the years, me and my brother are 11 months apart. Okay, we grew up, with your fist fights and such. I've seen them boys go back and forth, and Joey usually is more the aggressor than Dylan ever was. Dylan's always been the guy that's, tried to, defend himself against the older brother, in my opinion. I've known him, I've known these kids. Me and my brother were in business together. I used to spend every day after work out there. I think them kids are like my kids. They're very tight.
And just so, and Judge, I know you'll give me the asked and answered if I asked it. Did you encourage Joe to go to his dad's house that day?
No,
Objection, S.
It was.
All right, I couldn't remember, Judge, and I think that was an important question I had. I don't have any further questions to this witness.
Any questions for this Mr. Backus?
Just a Mr. Backus, you saw Joseph on that day, correct?
yes,
On November 4th. You see Joseph in the courtroom today?
no,
On that day of November 4th, did Joseph have a gun on him or any sort of firearm?
he actually asked me to come see his daughter in the car.
Please just answer my question. It's a yes or no. Did he have a firearm on him on that day? Joseph.
Yes, in the car.
How do you know that? Did you see that weapon?
Yes, he took me back to his car, opened his trunk and showed it to me.
And
And he also had a bow and arrow in the trunk. Hunting gun and a bow and arrow in the trunk of his car.
nothing further.
Just one question. Tell Joey anything about going over there that day?
Did I tell him to go over there?
No, did you tell him anything about going over there that day?
No, that was all his idea.
But did you
I
have,
knew you couldn't do just one question. Go ahead.
did you give him any advice from you about him going over there.
Yes, I told him it was a bad idea.
I don't have any further questions.
Any recross?
Yes, Judge. Mr. Backus, did you ever approach Joseph and tell him to back off from prosecution or try and intimidate him in any way?
No,
Did you ever threaten Mr. Backus with a weapon?
no,
What was Mr. Joseph Backus wearing on that day?
I honestly don't remember.
You said he showed you a bow and arrow. Can you describe that bow and arrow?
Here's a compound bow.
It was a what?
Compound bow for hunting.
Okay, what color was it?
Camouflage, I believe.
Was there any arrows attached to it?
It was in a case with arrows.
What color were those arrows?
I don't remember.
As well, right?
Yes,
What color was that firearm?
I believe it was black stock.
It was what?
Black stock.
What do you mean by stock?
The stock, I believe, was black and the barrel was black. I don't remember the size of the caliber you said it was.
Okay, was
It
there
a hunting gun?
was there an ammo attached to that gun?
I don't know if there was ammo in it. I didn't ask him if it was loaded
Are you how do you know that it's a firearm and not a BB gun?
because he told me it was his new hunting gun and he wanted to show me his
Oh.
bow.
Okay, you said it's his hunting gear?
He said, yeah, this is my hunting gun.
Okay,
He says this, yeah,
okay, nothing further.
Okay, so you can step down. Watch your step on the ramp.
thank you.
Thank you for your time. Any other defense witnesses, Mr. Mullins?
We would like to call the officer in the case. We just want to get his name correct. Is it Officer?
I'm gonna suggest it's either Zeismer or Lujovic. I'm not sure if I'm saying it right. Officer, come on up. Raise your right hand. Swear affirm, tell the truth, the whole truth, nothing but the truth today.
I do, Your Honor.
Come on up here, watch my ramp, don't trip up. Settle in the witness chair. After you've settled in, state your full name.
Officer Travis Ziesmer, Your Honor.
Say it again.
Officer Travis Ziesmer.
Ziesmer, thank you.
Yes, Your Honor.
Is it Seasport, right?
Ziesmer, sir.
Officer Seasport, did you respond to a call on the 4th of November, 2023?
Yes,
And you had contact with did you have contact with the complainant in that matter, Mr. Joseph Backus?
I did.
And do you recall whether or not you interviewed him at a BP gas station in reference to this case?
I did, sir.
And at the time that you interviewed him, did you have a body cam that you were wearing?
I did, sir.
Do you know if that body cam was operating correctly on that day?
To the best of my recollection, yes, sir.
Sure. And if I were to show you a video, would you be able to tell me if that would accurately represent the circumstances of you interviewing Mr. Backus at that gas station?
Yes, sir.
And would your body cam have recorded your question and answer? Look, back that question up. You wear a body cam, and when you turn it on, the purpose is to record interactions between witnesses or civilians when you're doing an investigation. Would that be a purpose that you would use it for?
Yes, sir.
And you were using it were you using it for that purpose today? I mean, on the 4th of November?
Yes, sir.
Okay.
I have it plugged into the HDMI thing that's on the table here.
Yeah.
Thank you, Madam Clerk.
Sir, Your Honor, can I ask him another question before we start this?
Sure.
When you interviewed him, did you ask him about describing the firearm that he told you was part of this incident between he and his brother?
I believe so, sir.
That's my background. I don't know why my screen isn't showing.
It's a lovely background too.
Oh, thank you. It's up in the Keweenaw Peninsula.
Beautiful.
Give me just a moment to check my settings here. I apologize. Your
Try,
Honor.
I was told to hit your desktop and hit display settings and it automatically will start going on. Is that so?
Oh, okay. So let's see.
How do you pronounce your partner's name?
My partner's name?
Walovich?
Yes, if that's the one.
It's pretty easy.
Yeah, if that's the one.
It's a lot easier than spelled.
Yes, okay, so yeah.
Judge, is it okay if I take 1 minute to step in? While they step
Yeah,
in?
while we're doing the tech stuff, sure.
Okay, there we go.
Do it quick. Spell it. Ziesmer. See, I would pronounce yours Zeiss.
Ziesmer.
Yeah, I would have said Zeiss with the IE.
I get it all kind of used.
Oh, I bet you did it butchered really well. Not as bad as your partner.
Oh, no.
Yeah, those J's completely throw you off with his name.
I play just a moment just to make sure the sound's coming through too. Okay.
Knock yourself out.
Oh, it's coming through my laptop, so there is an issue with it.
No.
Mr. Jerome, if I understand correctly, really all we're after is the audio on this.
Yes.
Push comes to shove, we can probably just play your laptop next to the microphone.
Okay, thank you, Your Honor. I think it's something with my settings where I think I just have to click this button and I think this is gonna fix it. Yep. Okay, there we go. My apologies, Your Honor. Thank
No
you.
problem. I love me some technology.
It's great until it isn't, you
And
know?
that was all pure sarcasm, just in case you messed with it.
Didn't miss it.
All right, we're back on the record, fellas. Ready to start the video?
Yes.
Display.
Yep.
She said it was black and silver, some black slide. Okay, looked like a river. Great.
Was that the complainant's matter describing the firearm?
It was, sir.
And officer, at any time did you recover a firearm that was alleged to be used in this incident?
Yes, sir.
If I were to show you a picture, would you be able to tell me if that was the firearm that was recovered?
Yes, sir.
Is that the firearm that was covered,
Yes, sir, it is.
recovered?
Yes, sir.
You got that picture, right?
Anything else at this point?
No further questions.
Officer, this weapon that was recovered, who did you recover it from?
Who did I recover it from?
Yeah.
We got it from Dylan.
And is Dylan in the courtroom today?
Yes, sir.
Can you please point to that individual, turn out an article that individual for wearing?
In the gray shirt on the far right.
Your Honor, let the record reflect.
Noted.
Witnesses that the police officer has identified the defendant. Where on his body did you recover this firearm?
He actually didn't have it on his body at the time.
Okay, where was it recovered?
It was actually in his room as
In
he,
his room?
yes, sir.
Was this weapon loaded?
That I don't know.
What did you do with this weapon?
The weapon was entered into evidence.
Okay, did you make the weapon safe prior?
I didn't enter it into.
All right, nothing to this.
Any redirect with the officer?
None, Your Honor.
All right, thank you, officer.
Thanks.
Watch your step. Can we send him back to wherever he'd rather be?
He can go back.
Yeah, you don't need him to stick around?
My only question is this, Judge, it's different because we're doing evidence. I would like to admit both the video and the picture.
We don't need him for that discussion.
No, but I mean, but we did it by video, you know what I'm saying? I
Right.
don't have something tangible.
Right.
Do you have an objection to that?
So I would just request that what's been shown is okay to be admitted, but I don't know what else.
Okay, all right, that's
For that time.
that's fine. I'm not asking something you didn't see. That's, I appreciate it.
Admitted. So is
The
officer,
OIC is free to leave.
how about Officer Olovich?
Any
The
officer.
other officer was there.
Yes.
You guys have a nice day.
Thank you.
Stay safe.
For clarity of the record, you should-
All right, any other witnesses from the defense, Mr. Mullins?
No more witnesses, Your Honor.
All right, any rebuttal?
Nothing, Judge.
All right, so I'm ready for argument, guys.
Judge, the people moved to find over on all counts. The testimony today by Mr. Joseph Backus is he went to go see his dad. He texted him, sure. His dad never told him he's not welcome.
Let me stop you. I heard the testimony. I don't need you to recap it. If we have a 3-day exam, that'll be helpful, but after this short one, I don't need it. Any argument, I'll let him respond to the argument.
Yeah, I'm gonna talk case law. Case law as far as a preliminary exam, what this court can consider in determining a bind over. Now, often, Your Honor, the court doesn't look at affirmative defenses and other things, because there could be questions of fact. What could lead the court to say, hey, that's for a trier of fact, and not necessarily in this court. But there are exceptions. And under the People versus Robert Redden, 290 Mishap 65-8485, and People, and they were quoting People versus Woltening, which is 272 Mishap 690. The court noted that in situations in which a defense is complete and there's no conflicting facts regarding the defense, it can be argued that there's no probable cause to believe that a crime was committed. Now, I'm asking the court to do a lot. Now I'm going to backtrack and tell the court or explain why I think that's relevant here. People versus Johnson in 2020 gave an opinion. Oh, I'm so sorry, Your Honor. I'm reading you the wrong case law. I got a specific case law. As I'm looking at use of force and what's allowed for an individual in a situation on their property. And I'm going to explain the facts and give the case. In this particular case, an individual pointed a gun at someone's face. And the trial court ruled that pointing a gun in someone's face was considered deadly force. Now, when you have deadly force that you use, you have a different requirement to show as the defendant in order to get the affirmative defense. And in fact, when you have deadly force that you use in an instance, that would be considered, you have to have a situation where deadly force is necessary and you're saving, your life is at risk. It's a risk of your life in order to do that. But the court in People versus Oakley, which is a 2022 case, 341, Mishap 28 says, pointing a gun at someone without more is not deadly force. It would be different if you pointed the gun and fired it and said, shoot. I was shocked when I read this, Judge, because I've been doing this a long time, and I would think clearly if you point a gun at somebody, that's going to be deadly force. The court specifically indicated that putting a gun and pointing at them in of itself, that's not deadly force. So in this particular case, if we are following the case law, Mr. Backus did not use deadly force when he encountered his brother. Even if you agree with his brother's story, that he pointed the gun at her. And I've got questions with that. And the reason being is, you saw the evidence. He described a totally different weapon that was used. That weapon that the police recovered, and the weapon that was alleged to have been used in this, had a desert storm color, totally different than the gun he described. We also heard the witness fight with the lawyer, kind of be flippant about different questions. We know he did not have a good relationship. We know he wasn't in contact. We know he reached out to his dad for his own testimony, and nobody gave him permission. He wasn't welcome. He left over 2 years ago with a dispute with the family. We heard testimony of his uncle that talked about the relationship between the two brothers and how the older brother was a little more of a hothead and the older brother would get the better of his younger brother, which is not unusual in a family. But this goes to the state of mind of my client when now, over 2 years later, his brother who's been removed from the place shows up and is there on his porch. And now his brother wants to see dad. Well, based on the relationship, it's the individual who is not engaged in using deadly force. It's a different standard. If this person reasonably believes that the use of some force is necessary to defend himself against that individual, they would be justified in it. I think the facts in this case kind of line up that way. You got an individual, all the things I told you about him. And furthermore, I don't think he misidentified the gun. He said it was right there, what do you say, 6 inches from him, a couple feet from him. I think the witness was not a credible witness. And in a preliminary exam, you're sitting as trier of fact and trial of law, and you can make a credibility consideration. My client is at his home. He has no duty to retreat. And when he's faced with a threat of his brother, and I think the evidence is pretty much square on. And I'm asking for a lot, but this is one of the rare cases where I think the stars line up and the facts line up, where he doesn't have to show he was facing deadly force. Even if he's wrong in his belief, but it's reasonable for him to believe that his brother's a threat, then I think that's enough for him to use not deadly force to remove what could be considered a trespasser at that point. And so I ask you to clap.
Thank you.
And so, the charges in this case are felonious assault and weapons felony firearm. I mean, that was a great speech on the use of intent to use deadly force, but that's not a requirement for the elements.
It was a great speech. It was a great speech.
It was, without question, if it was regarding the intent of using deadly force. But unfortunately, for brother counsel, that's not the elements for the crime. So the elements in this crime are make an assault with a dangerous weapon, but without intending to commit the crime of murder or inflict great bodily harm less than the crime of murder. So the weapon that was used in this scenario was a firearm. It was recovered by one of the officers. The testimony by the OIC today was that this firearm was recovered from the defendant's bedroom. The testimony today reflects that this weapon was used and aimed at the face of the victim. And the victim stated that he felt in fear. He panicked. He had to leave the situation. And that's what he did. Nothing on the record indicates a self-defense kind of claim where the victim approached the defendant with a weapon. He stated he wasn't armed. He had no knife, nothing. So I believe without question, probable cause, the standard of probable cause has been met in regards to these two elements, and we're gonna move to bind over on these two charges.
Thank you, Judge.
Go
ahead, I'll give you a shot.
I think the important thing to bring out is this goes to an affirmative defense that my client has. It's not necessarily we're going through the elements of it. We're talking about an affirmative defense. In the case law that I cited, People versus Robert Redden from 2010, published case of the Court of Appeals, allows you to raise a affirmative defense at preliminary exam. Typically, affirmative defense is going to be raised at trial. I know that. But that case specifically says you can do so. And in doing so, you can consider the credibility of the witness and whether or not it's reasonable for my client to feel threatened by this individual. You heard the facts, and I'm not going to repeat all the facts of the relationship. As I relate to the gun, that's the gun that's alleged to be used. That's not the gun that was identified by the witness. Again, going to his credibility of whether or not this crime really was committed. And what they say is this: if the affirmative defense has the issue, the elements of the affirmative defense are met, this court can find that probable cause that a crime occurred did not happen. Because that's one of the things, whether he committed a crime, and by probable cause, the elements of the crime have been present. So for those are the reasons why I think it's appropriate for you to quash Feinberger in this particular case.
Judge, I'll be very, very brief, I promise. I don't know what the affirmative defense is for. This victim went to the home of his father to show his father his newborn child. Didn't go there with a gun. He knocked on the door, he left. They didn't want him, he left. That's all that happened here. It's a sad case that a brother is pulling out a gun and aiming it at his brother for wanting to, his older brother show the family his newborn child. I think this is a very, very sad case. And it's sad to see that it happened. And we're still moving to bind over because the elements of the crimes have been met. Thank you.
Thank you both. The trier of fact. The testimony was that there was more than pointing a gun. There was get to stepping while you still can. That's a threat. And I'm a huge stand your ground, all that, but you don't open your door and point a gun at somebody. There's got to be something to precipitate it. If you ask them to leave and they refuse, if they make threatening gestures, whole different ballgame. The testimony today was there was no conversation. He was not asked to leave. The gun came out and get to stepping. This is a trier of fact issue. So I'm going to send it downtown. Your next court date's going to be February 14th at 9 a.m.
February 14th?
14th. Yep. 9 a.m. Bond will be continued unless I hear something quick. Bond will be continued. Wish you luck downtown, sir.
You want just one last thing? Those two exhibits, will they go with it?
I don't know how we're going to do that because, yeah, we don't.
The record marks of those two exhibits, the video that dealt with that short interview with the brother regarding the description of the guns, as well as the.
Yeah.
No, thank you. I appreciate it.
Yeah, we can do that. Right, picture of the gun. Just put in the notes that images were shown and admitted. Which one are you going to do next, Mr. Mohammed?
I think Michelle Japanga, can I just go check?
Yeah, we've got her on Zoom. She's been here for quite a while. Gentlemen, you don't have to go far, but you got to get out of here. Good luck, Don. Good luck, Don.
I still have one more, Your Honor. Hopefully, he's not going to pull my deal now. No, I'm joking. I'm teasing.
Mr. Mullin, I was informed that the exhibits are for this exam only. So when you go to downtown, they're probably going to be shot.
Oh, look, no problem. Just I'll file a motion to quash find over. I want to use that. You can only use the lower record.
Shannon.
As long as they're not part of this record, that's all that.
I can't do that. I don't have video. I can't do anything. I do is I transcribe it.
No, that's all I need.
No.
I'll make the rest of the
Money and he hadn't done anything that the school corporation wants.
So you just came in today?
Yes.
Okay.
And Al saw him this morning.
Okay.
So I'm trying to send it to me.
Good.
And once he's done, with all the information, we put him in search over to the commission. They have shelter for him.
Really?
Yes. It's intended.
Yes.
So my thing was checking
Shelter
with you.
now?
Yeah.
Yeah.
Mike was check with you.
Do it.
To see if we can, I can drop him off, take.
Sure. I don't think you should go alone though.
Huh? Yeah, I'll take this in.
Yeah.
Okay.
Yeah. Taking. Great.
Good.
Perfect.
Just wanted to clear it out. Check.
Yeah,
I'll
no,
let him
we
write
did-
in those books.
We just build goodwill with him. Now maybe we can close our files out with the community service.
Yeah.
Yeah,
Just wanted to
yeah,
make sure
yeah. Be
everything
careful.
was good.
Yeah. Thank you. Yeah. Yeah. Wise guy. It's the black shirt. Yeah. All right, gentlemen, appearances for the people versus Michelle Japanga.
Good afternoon, Your Honor. Mohammed on behalf of the people, PA 6771.
Good afternoon, Judge Oakley. Good afternoon to your staff, Neighborhood Defender Service, Terry Martin, P84592. I appear on behalf of Miss Michelle Japanga, who appears by Zoom. Ms. Japanga, state your full name.
Thank you, ma'am. She's still in treatment, I assume?
Your Honor, I had Ms. Japanga Zoom in today because right before I got a call from her around 11:30 and from her boyfriend, actually first from her boyfriend, that she had a seizure. So she's an epileptic, and you had previously granted her permission to appear by Zoom because of her epilepsy. She cannot drive. She had another seizure just today. Heard it from her as well. I didn't want to jeopardize her health in any way. And I had also heard from Detective Rice that an officer who I believe to be a necessary witness in this exam, that would be former Officer Kilgore of formerly of Romulus PD, is not present. So I am, for those and other reasons, if you'd like me to put them on the record, asking for a dismissal.
Is that a no? She's not in treatment?
She's not in treatment.
Okay, all right. Yeah, you're gonna have to give me more than she's had a seizure and they've got one missing witness. What other reasons do I have for dismissal?
Well, Your Honor, the missing witness is the officer who, in this incident, which was November 2021, who first approached Ms. Japanga, found her overdose. That's a critical issue for exam because that would, under the statute, show you, that would make it that she had not committed this offense. Now, the only officer that we have is an officer who arrived later after this had occurred. In addition, we don't have body cam. And I had Judge Martin sign a discovery order requiring that they produce body cam depicting the interactions with Ms. Japanga. I was provided some other forms of digital discovery, but was informed, Mr. Mohammed showed me communication from the OIC. I'm not sure whether it was Detective Rice or the previous OIC on this case, that body cam no longer existed.
All right, so the initial contact between her and, was it Kilgore?
Kilgore.
That we don't have that video.
We don't have that video, and we don't have Kilgore.
Okay, all right, response?
Judge, we did, after that discovery order, from what I recall, my computer is down at the moment, but I do recall us sending some digital discovery that we got. And as Mr. Martin disclosed, some stuff just didn't last over time. I think this is a couple years back. We are ready to move forward today. We do have Officer Dorsey. I understand Ms. Japanga suffered seizure in regards to that, but we are prepared to move forward today. We are missing one officer that does play an important role, and so we would request a helping part in regards to that officer.
Okay.
And
is there, hold on a minute. Am I safe to assume that you don't have any civilian witnesses, just law enforcement?
No, police officers.
All right. So number one, she just had a seizure. Number two, you want Kilgore. I'm assuming you don't know if you can get him or not.
Yeah.
Do we know?
He works down in Auburn Hills. We're able to get a hold of him. This subpoena came in late, so he is available. I just, we weren't able at the time to get him for this day.
All right.
And just for the record.
So hold on. I don't want to start it and finish it later. That's selfishly, it's bad. It's just rougher on me. I also think that it's not probably the most compassionate way to handle it for Mr. Japanga. I'm inclined to adjourn.
Your Honor, I would respectfully renew a request for dismissal, not just because of the missing witness, but because of what I'm saying is a discovery violation that will prejudice Ms. Japanga if this case were to go forward.
But if I understand correctly, you've got everything they've got. They just don't have what you want.
Well, what we have is a concession from the people that this body cam footage previously existed, and they allowed it to be erased destroyed, that is a Youngblood violation. That's a due process violation. That is, they once had access, control of possibly exculpatory evidence, and they failed to preserve that evidence.
Yeah, but I also, and I'll give you a chance to argue it, but I also think there's got to be a bad faith before the result is a dismissal.
Youngblood does require bad faith. Bad faith can arise from blanketly, maintaining a system that erases discovery, including on pending cases. I mean, this isn't just, our old closed cases. We can say, it was just a technology failure. But at the end of the day, if you have a police department that is knowingly or that knows that footage from pending cases is getting erased and destroyed, I would argue that's enough for bad faith for Youngblood. And even if you don't need Youngblood, I would argue it's a Brady violation, which doesn't require bad faith, where you had possibly exculpatory or at least impeachment evidence that was in the possession of the people that has not been provided.
All right, so let me ask you this. What do you think the video is going to show that helps her?
I think the video would show that the police officers who responded were responding to what appeared to be a drug overdose and what I actually believe was a drug overdose.
Right. That,
under the statute, I mean, I've got it right here. Basically, all the sections of the Controlled Substance Act, including the one she's charged under, which is 333-7403, contain a subsection 3, which states that an individual who requires medical assistance and is presented for assistance by another individual, if he or she is incapacitated because of a drug overdose or other perceived medical emergency arising from the use of controlled substance, and possessed an amount sufficient only for personal use, and this evidence of the violation is obtained as a result of the individual seeking or being presented for medical assistance, that individual is not in violation of the section.
Okay.
Now, I would say that—
Hold on, I'm with you. So is it the people's position that she was not suffering effects of an overdose at the time of the interaction?
I think that is the people's position, is that there was a response for a 911 call. The officers responded, they made contact with the defendant, and in plain view, they did observe drugs, which were the suspected cocaine.
But she was conscious, she was interacting.
She was conscious, and it was her own words that it was cocaine.
If I could.
Yeah. I just want to make sure I know what their position is.
The nature of the 911 call was an unconscious female.
Okay.
When, according to the report, when Officer Kilgore responded, Ms. Japenga was unconscious. He performed a sternum rub on her. And though that did arise her, she was later, nodding off again.
Right.
And Judge, just for the record, I'm pretty sure the person who did that 911 call was her friend. And I don't know if that helps.
I don't think that matters under the statute.
I just want to make sure I'm disclosing
everything. I think the determinative factor in the statute is her condition at the time of the initial interaction. Would we all agree on that?
Yeah.
Okay.
I'm with you.
Okay. I'm not going to dismiss it at this point. Here's why. If Kilgore's testimony is all of what you just told me, I think then that's the argument.
Yes.
She was in the midst of an overdose at the initial interaction.
Yes.
Which then I think triggers subsection 3.
Yes.
I don't need a body cam. If he says, no, I got there, she was talking, it was fine, blah, 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 then you can renew your motion because, yeah, I think at that point, the body cam could impeach that testimony.
Well, for purposes of today's argument, given that the people did not subpoena Officer Kilgore, would you entertain looking at the reports in which Officer Kilgore does state that he found Ms. Japenga unconscious?
And I'm going to object to that misrepresentation Mr. Carey is making to the court and for the record. Subpoenas were sent weeks in advance.
Oh, no, don't even go there because I don't think he's trying to paint you in a bad light. He's saying we don't have the cop, but we've got his record. Can we just go forward with his report? Any objection to that? I mean, I'm okay with an adjournment if you want to get Kilgore here, but if you want to save the time and just go on with the reports, from what Mr. Carey just told me, the reports make the argument. I mean, I haven't seen the reports, obviously.
Yes, and I would need to grab my computer and pull them up, but I can do it in about 30 seconds.
I feel strongly both ways, so.
So, Officer Kilgore, it does state that he performed a sternum rub to wake Miss Michelle Japanga. Japanga woke up and when asked what she had taken, and that's when she made the statement that it was possibly cocaine. And that's a representation I want to make to the court.
Okay.
And I'll, live by your decision.
Well, I think we can all agree if he's doing the sternum rub, it must be because she was non-responsive when he first approached her.
Agreed.
I'm dismissing it.
Thank you, Judge.
And you guys can build the record. You can take the dismissal because the discovery violation, because of section 3. I think we could have a full-blown exam. I'm going to be the same place.
Yeah, I think section 3 doesn't apply.
All right.
Thank you.
Okay. Ms. Japanga, you're all set. Case dismissed. I'm going to write it up as dismissed after exam. Just because I don't think it matters too much, but that's why I'm going to write it up.
Works for me, Judge. Thank you very much.
Good luck, ma'am.
Your Honor, thank you very much.
Thanks, guys. We still got a couple files, don't we? What else do I have?
The next one is Michelle. And then we have, well, Michelle was the first to 12:30.
Hey, Joe. Yeah. On the way out there, find out if we're ready on Miss Shaw.
Michelle?
Yep. Go ahead.
I appreciate it. Yeah. I think that's the right choice.
What's next?
Your Honor, have a good day.
You as well. Stay safe. Mohammed, are you doing Michelle too?
Yeah. Judge, that last one, that drug one, with it's a codependent one. I'm gonna need a minute to talk to officers. It's kind of a big case.
What's the name?
Um,
Michelle, you mean? Or
no, it's Stacy Jackson
Okay.
and Dwight Jackson.
can we,
I'm sorry.
you want to talk before you get to Michelle?
Yeah,
Go ahead.
I'm just sorry because I didn't anticipate that FATB.
No, it's all right.
Okay, remind me. And then.
We're rating pretty good. You have a lot of files up there?
Yeah, I've got Shaw, I've got Crenshaw, and then I've got these, some of those are probably no shows.
So that Sarah Pornier, no show. What?
What's that? Oh, you did, yeah. Yeah, for an off-the-cuff argument? Yeah, you did a great job. Both of them. Yeah, tell him that. I agree.
I absolutely will.
No, that's a do-gooder thing. I think in certain circumstances, absolutely. Yeah. I'll go to the job. This says he had another file, but I don't know which pen it is.
Well, Crenshaw never did show. Yeah.
Put it on that file there. Oh, I got a file.
Oh, we scratched, didn't know.
I know, because somebody told me it was here.
I'll double check.
Oh, no. Crenshaw was scheduled early this morning, but Kerry Martin told him to come in late today because he had some other stuff late. So you might check with Martin whether or not he's here.
Okay, all right.
Did Gracie leave?
What's that?
Did Gracie leave?
I think so.
Okay, that's all. Perfect. For drivers?
Yeah, for the commercial.
No, but the thing is, it's to a company, so it's not gonna affect anybody. It's not gonna be me. Why is it gonna affect the city? We don't have the driver's license number, we have absolutely nothing on. It's for the company.
Who
And
did,
it's a registration.
I was a truck cop for a long time. You want me to help you?
Yeah. I get one. It's gonna give me a 70.
Mhm.
Then it's gonna be- ticket was originally a failure registration. He corrected it.
Yeah, it's in the company name.
So it's not carrier.
Oh, wait a minute.
I'm so happy that we. Yeah, okay, how much is that one?
We usually want 180 or 200.
Okay, perfect. No, there's a driver with it.
Yes, it's over here.
Would
So
you do a double parking? I mean, you want a civil infraction, right?
yeah, but I don't know if double parking would fit. I would normally dismiss it, but the only thing is the CDL holder, and our office has like a big policy.
It's the company.
It's the company, it's not even the driver.
So it's nothing for the driver, it's the company.
Okay.
Well, no, I'm just saying,
Yeah,
it's in the company's name.
It's not a commercial flat.
Okay, then yeah, dismiss it. 9 out of 10 times I would dismiss it, only when it's CDL, I'm hesitant because our office has like some weird
Yeah.
policy.
Yeah.
It's company's name, so it's not even the driver has, it's not really
So you're moving to dismiss?
Yes.
Yeah. And just so you know, the CDL thing, where I think we're all sensitive about it, is safety issues.
Yeah, you're right.
This isn't really a safety issue, because we don't want a guy with a Class A CDL that's an unsafe driver hauling our petro down the road. Yeah.
Okay. Look at, I appreciate it.
Would you agree with that?
I wanted to.
Would you agree with that? The reason the prosecutor's office is tough on CDLs is because it's a safety issue, not a registration problem.
Well done. Well, I get something, can I get a copy of that to give the client, or?
Yeah.
Or am I asking for?
And he's got paperwork says it's right.
Your Honor, he's a good young prosecutor. This one
Huh?
here, he's a good young prosecutor.
I'll tell you what, they sent this kid out here. He didn't even know, he didn't have a clue how to do a plea agreement when he got here.
Well, you know what? You can tell he's got natural skills, a natural drive to do the job. I said that to him. I like him.
You know, the other thing I really like about him, he's humble. He'll ask questions. He'll take direction.
And he's got the right temperament. You know how hard it is in this job.
Yeah.
You know, and defense attorneys are jerks.
Yeah.
We say things, cases.
Yeah.
He did a great job.
He did a great job with your argument that he got blindsided with. And then Kerry Martin just hit him with another blindsided argument that I thought he handled real good. I think I really, first of all, I told her earlier, I like him. And you know what? If you're likable, that covers up all kinds of sins.
It does. It does.
Yep. Yeah. But you know what? When he was first here, I think he's still doing it, but when he first showed up here, he'd pull a defense attorney aside and say, look, I gotta make an offer on this case. What would be a good offer on this case?
Smart. He's smart.
Because he wasn't getting any help from downtown. No.
I mean, I hate to say that.
Well, you know, Trish, I don't disagree with you. Trish Gerard was out here. You know her, domestic violence. And I can't even tell you the last time I saw her, but she used to be assigned to our court as a domestic violence prosecutor. Now she's the head of that division. I mentioned him to her about the fact that it's, it's sad how little training. She says, Judge, I'm here. I'm not supposed to be in court. She says, we don't have time to train these kids. Yeah.
He did a great job.
No, I thought so too.
And you know what's tough? I did want to tell you that.
Well, those are pretty new cases you were going to do, 21, 22. Right. On the case where they said it wasn't deadly force, I'm assuming there were no words. It's like gun in face, nothing else.
I don't think there was words. It was really interesting. And it was a little better that the neighbor had punched him one time or something, which gave it was reasonable for him to use up
To pull the gun, right?
You know, I've got witnesses.
Yeah.
You know, it's out of your court.
Yeah,
Right?
yeah.
I got witnesses that are going to testify how. Yeah. He's.
I hate these family things though, because there's no repairing this. And you know what? The 2-year-old is gonna suffer.
I do too. You
Yeah.
know, and I even asked.
Yeah.
And you know, I'm
Yeah.
afraid so. But it's tough. Those are tough.
You know, I've been looking into this whole restorative justice thing. Because between you and me, this job is not nearly as much fun as it was 3 years ago. And I gotta get at least to the end of my next term, right? I got another term I could run for, and at this point, I'm just trying to find some way to stay engaged for the next 4 years. So I was thinking of the restorative justice, you know, with the juveniles, and, you know, I'm getting real involved with the Rhino schools right now. This is a perfect example where, you know, the restorative, well, for the model, this case doesn't fit.
Right.
You know, with the weapon and everything, but family situations, man, get them all in a room and say, what do we got to do to move forward so this 2-year-old can know her grandpa and her uncle?
And you know, Grandpa wants to know the kid.
Oh, I'm sure.
But he's got an ad, you know, and it's all, you heard the divorce. Mom and
No.
dad divorced.
The kids picked,
Yeah.
this one picked the wrong side,
Yes, that's right.
right?
So
I got a buddy that's going through that right now.
it's horrible.
Got 5 kids, and he has not had a conversation with his only son since the divorce.
I don't know. I don't know what to do with it. And there's so much emotion involved. This is why some stranger.
No,
showed up.
those are easy compared to
Yeah,
these,
right.
yeah. Because this goes back to who got what for Christmas in 1978. It's like doing divorce work, right?
Oh.
It ain't about the toaster. That's just what they're fighting about.
I hate it. I do hate it.
Yeah. No, good luck, guys. Oh, you're done now.
Yeah. Thank you.
All right, so you confirm that with Mark.
Out there.
The attorney. Just check with the attorney. I'll get some water. We did that. We did that.
Yeah.
Still good read. And those guys came back and they just went back to their life. I've been doing this 25 years. I've never had a bond.
Mr. Michaud's objection to be, and what I have also represented to him regarding that objection. Mr. Michaud, I think the court record will reflect, had a probable cause conference first on November 29th and then again on December 20th. I have disclosed, I mean, I think I've been very transparent with Mr. Michaud that probable cause conference is a bit of a misleading name because probable cause conference under the court rules does not require that probable cause be established.
Right.
At the second probable cause conference, Mr. Michaud was caring for a sick relative, so he wasn't able to attend that probable cause conference scheduled December 20th.
Which didn't hurt him at all.
Right. I represented him on that day, and I asked the court to waive his appearance so that he could remain with his family.
Which we
I
did.
understood to be his wishes. I may now understand differently that I misrepresented him in some way, but you know, my goal was just to be able to conduct a probable cause conference where we were going to find out if there was any offer, whether, you know, whether discovery.
You don't have to tell me what they are. I know what they
I
are.
know, but I'm just trying to.
And I'm trying to explain it to him too, but I'm not going to talk over him.
Right.
And I'm not going to play that crap today.
Right.
So if you want me to explain what's scheduled today versus what was scheduled last time, I'm happy to do that, but you got to be quiet while I'm talking. Clear?
Oh, dude, I hear you.
All right. The last court date that we call a probable cause conference is like a pretrial on a misdemeanor. It gives the party.
That's going to be it for today, ladies and gentlemen. It's been fun. You all have a wonderful evening. Ta-ta and ciao-ciao. I will see you guys on the next one. And behave yourselves if you can.
Breakdown, you're the one I call. From the mountains high, come down to it all. With your tools in solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do, from the highest peak, I can see it through. With your care and touch, everything's okay.